don't see that. Where's the recording button going? Oh. Okay. Good afternoon. My name is David Esch, and I'm with Piedmont Score. And today is Patents and Trade Secrets, presented by Doug Lineberry, who's with Offutt and Kurman. For those of you that might not know SCORE, we're a volunteer organization, and we provide assistance to small businesses and nonprofits. And our website is www.score.org or Piedmont Score, which is ours. We're 100% volunteer based. We provide one-on-one mentoring as well as these educational services. Today's workshop is being recorded, excuse me, and we will use the Q&A for any kind of questions during the workshop, and we'll either answer them online or in person during the presentation. As Doug has pointed out, many times your questions lead to his next section, meaning it's very timely. So at this time, I would like to introduce Doug and let you take over and introduce yourself further with your great stories. And Doug's been a long time collaborator with SCORE.
But David, thank you so much. And guys, what I'm hopefully doing right now, and David, can you see my full PowerPoint presentation on the screen?
Yes.
Awesome. So guys, what we're going to do today, and I want this to be very informal. David and I are kind of laid back guys. We want y'all to be laid back too. I can see your names as well, which is awesome. So Bill, Bonnie, David, Frank, Harry, everybody. I see your names. I will click on you as this runs through. But today's opportunity for us is to go through and get rudimentary understanding of patents, trade secrets, and how artificial intelligence impacts those. And when we do that, what I want y'all to understand today is this is not some sort of fuddy-duddy situation. I want y'all to be like, hey, if I've got a question, ask Doug. Guys, if I don't understand or know it, I'll have you rephrase. But if I don't have the answer, I'll tell you. I'm very honest about that. I don't want any guessing today on my part. You guys can guess all you want. And I fully encourage y'all to ask questions. I've got the screen pulled up so I can see our chats. You know, David will let me know if anybody's got anything to say as well. But I encourage everybody here, ask. But I've got the chat bar pulled up. You guys feel free, and we'll delve into it. Now, to respect your time, I've set a timer, so at 1 o'clock I shut up. You guys will be shocked that I'm capable of that, but I really am. But for today, we're going to discuss two areas of intellectual property law. And you'll see these are highlighted in green on this slide. We're going to talk about utility patents, basically how it protects and how an invention works, how you make it. A design protects what it looks like. And then a trade secret. And these two are juxtaposed. That's why we've got these two set up today, because they are not the same creature. They don't protect things the same way. And we need to make really certain that we know which protection we want to use before we say, hey, this is the way we're going. So again, today is patent and trademarks. We will have a later one on, today's patent and trade secrets. In a few weeks, we will have one on trademark and copyrights. Hopefully you guys will come back to that if I don't chase you off. Now, one thing we want to go through today is when we go over this, we need to understand first, what are the mistakes folks make? And one item that will get everybody here, and I'm talking to everybody on our chat, everybody in the crew, is that all of you have IP of some form. You know, we've got 20 attendees today. I promise everybody here, you know, Laura, Mel Flaming, oh my gosh, we let him in. David, we're going to have to talk in the future. Y'all, if Mel asks any questions, I'm going to raise Cane on him. Just understand this is a old relationship that goes back a long ways. But like, you know, William Becker, looking at you, my friend, we need to make certain we understand what our IP is before we go anywhere. And what I want us to do is to understand we've got it. You know, maybe not everybody here has a patent. I promise you, you have at least one trade secret. Let's not ignore that. You know, there is always that impetus of, I must get to the market. I must get to the market. I don't want us to forego protection for the sake of convenience. That's just never going to work for us. I want us to be a little focused on this. I want us to at least consider protections before we do or don't implement them. And also, we want to use the correct type. Because if you've got something that's a trade secret, by the end of the day, you'll know that a patent is the exact wrong way to protect it. Protecting your stuff in house. If y'all were on the call a little earlier, David and I were talking about a client last week that asked me about Trademarks USA. And these guys have this really low price, and they're like, hey, it'll cost you $1, and here you are. But then there's a subscription. And the subscription runs for the entire time that the trademark is just sitting at the trademark office, not doing a thing. Then, if you get a response, you've got to raise the subscription amount. Then you've got to pay somebody to deal with it. The reason I'm bringing this out to y'all is that services like that in LegalZoom may seem like a great deal on the front end. At the end of the day, they're not very substantive. They don't do a good job of protecting what you've got. I caution you not to use those. They can end up to be very bad ways to try to protect, and they'll cost you a lot of money to do it. Use an attorney. Another thing I was telling David, for y'all that were listening, if I do something dumb, sue me for malpractice. If I do something dumb, let the South Carolina bar know exactly how dumb I am. Use that, because that is one of the benefits of having an attorney is I've got organizations that keep me in check quite well. Now, as we run through this today, I realize I talk fast. Anybody has a question, ping it. I will stop occasionally and ask for input from you guys. I may call you out, so be prepared. Nothing mean about this. I just find that it builds a better conversation for all of us. Now, our options, if you have an invention, are these three. You can apply for a patent. We're going to be talking about that today. Part of the reason we're here. You can keep it a trade secret. And again, that's the exact opposite of a patent. I want us to understand that going in fully. Or you can do the, hey, I'm going to tell everybody about it. I'm going to disclose this thing. I'm going to put it out in the universe. Everybody's going to know about my invention. The reason you may do that is you might be like, hey, I don't have the funds to pay for a patent. Hey, I don't want to have to worry about this stuff. But what I do want y'all to know is these activities might harm you for both patents and trademarks. So you look at these as three very distinct options. And if you choose one of these, let's make it an informed choice. Know that if you're applying for a patent, you don't want to put your trade secrets in a patent application, because the patent becomes published. It becomes a public record. It is known to everybody. You can go to Google Patents, and if a patent publishes, it will be on there. You can type it by the inventor name, by the name of the invention, whatever you want, you can find it. A trade secret, gang, is exactly what it sounds like, a secret that helps you trade. Now, these disclosures, a lot of people are like, hey, I'm just going to go throw it out there. And you can do that by selling the product. You can do that by doing a presentation like today. Let's say they invite you. Oh gosh. Okay, just read the chat function is not open today. Please use the Q&A for submitting your questions. Y'all feel free. I will sit here and pull up Q&A right now. So yeah, I've got the questions pulled up. I will decrease chat. If y'all have anything to ask, feel free. If you don't have to raise a hand or anything, just type it in there and go to town. I am looking at it, so we've got that pulled up. David will be monitoring it too to make certain we answer. But also, let's snap back, because any of these activities you take may have a negative impact on your protections. Because when you put things out in the public, when you disclose your inventions, when you disclose your trade secrets, it could be very detrimental. Now, for our inventions, I want you to be excited. It's part of the reason I love working with small clients. You guys have energy. You're out there, you're excited, you've got a new company, you've got a new product. It is freaking awesome. I love it. However, remember that our inventions are very disclosure sensitive. And if you developed a new fusion reactor, I do not want you to disclose that and go out there and start talking at Clemson and USC and other places about how it works. That is a terrible thing for an invention of that caliber. I don't want us to have early disclosures. I want us to think about what we're going to do. If we go out and talk about our new fusion reactor, and say you could jump on today and you show schematics and we're all looking at it, you can lose the ability to protect it. You can lose the ability to protect it everywhere. And the U.S., if you did it right now, you'll have 1 year. So you'll have until June 12th of 2026 to file a patent. But you've shot all your rights in Japan. You've shot your rights in Europe, Mexico, Canada. Other huge markets will not allow you to file a patent because you disclosed it without having a patent on file at their patent offices first. So that's a huge danger. You have to be very careful that you do not, A, trigger the minimum deadline of the U.S. or destroy your foreign rights. Another thing you may do is that you might generate your own prior art. You may talk about version 1 of a device and then file a patent on version 2 2, well, guess what? The patent examiner can go in and find those disclosures about version 1. They may see where you've sold it. They may see where you put out a piece like a white paper about it, or you had it on the website for sale and described it. They can very readily find that and use it against you. Another thing it does is it gives your competitors an advantage. If you're just out there talking about your products, they may be watching you like a hawk and learning what you're doing. So I want y'all to be very careful with any of these aspects that you do that impact your products. Now, what are the mishaps that happen? Guess what? We don't document who made it. If you're working with somebody and they're an inventor, and again, this is a question that's got to be decided early on, did they contribute to the inventor process? Are they actually an inventor? If they're just a welder or somebody's helping you create an idea that's entirely yours, they're not an inventor. But if it's your idea and their idea combined to get to this third phase, they probably are an inventor. So we need to make certain that we know who invented it. We also want to make certain that if they're inventors, that we have an assignment. IP should never be a personal property. It should be owned by an LLC, an S Corp, a C Corp, some sort of corporate entity. And to have them own it, we need to have an assignment from the inventors to that company. If we do not have that, then we're going to have a problem because we're going to have dangling ownership. Nobody wants that. Let's say you go to sell, and guess what? Me or one of my brothers or sister attorneys come in and we're like, hey, I see this patent's been filed. It's still in the name of the inventors. I'll need an assignment. Well, if everybody's still happy and copacetic, then that's great. We get an assignment. Everything's taken care of. Everybody's happy. Let's say there's been a falling out. The inventors no longer speak. They no longer send Christmas cards to each other. It's going to make it a little more difficult to get them to cooperate. And so I want this done early. This should be something that happens at basically step 1 of the patenting process. Get those assignments knocked out. There's always that tendency to delay filing, to say, hey, we're not quite ready. We don't have the money. Well, then if you're planning on filing for that patent, you need to figure one of 2 things out: how to continue your business without inadvertently disclosing it, or find that money. And haggle, if you're going to talk to your attorney and you're like, hey, I'm a small business, I can only pay so much, haggle. I've done other presentations for SCORE and the SBDC and other organizations in the state. I encourage folks to haggle. I encourage you to go out and try to get the best price you can. Documents are not locked in stone. If they are locked in stone and you don't like them, walk away. Guess what? There are ways that you can make these things work. One thing I don't want you to do, you're going to see an example of this a little later on today, is I don't want you guys using Chat GPT to generate apps. You're going to be tempted to it. You're going to be able to tell it something. I have a very simple example here in the slides a little later on. Told it to go out and generate something for me. And by God, it did. And I want y'all to be very wary of that because it is a Chat GPT. I want to show you some other things I asked it to do as well, and sort of the feed we got back on it. So again, use an attorney to do this, guys. Provisional application is a little more forgiving, but when it comes time for a utility that's going to go in front of an examiner, you absolutely positively want an attorney's hand in that. You do not want it to be a Chat GPT creation. It doesn't understand the nuances of prosecution. It doesn't understand how to make this happen with an examiner. You need an attorney to do it. Last thing, deadlines. If you miss a deadline at the patent office, your application will go abandoned. You will have to figure out, hey, can I revive it? Has too much time passed? Have I been lax and, we're in trouble? Or was it just a day or two? And that's probably can be forgiven with, of course, paying a fee. Now, how do I want you to square away your patents? Those assignments. We talked about that. It is critical. Get those when you file the applications, especially for somebody who's not necessarily tied to the company. But all inventors, and I don't care if they're tied, I don't care if it's your best friend, your partner you've been working with a million years, get those assignments. If you do licenses or royalties with folks, I don't want handshakes. Handshakes for businesses always end up in a fist fight, and it's just the way it happens. I don't want y'all doing that. I want y'all to be protected. Be aware of your maintenance fees. Patents, like trademarks that we'll discuss in a later session, have ongoing fees, and you have to pay the patent office at the 3.5 mark, the 7.5 mark, and the 11.5 mark to keep the patent alive. If you miss one of those patents, it goes abandoned. And that's a 4-year span between those patents. My memory, I can barely remember what I had for breakfast last week. I definitely will not set a mental clock and be like, in 11 and a half years, I've got to pay this fee. So again, that's another benefit of using an attorney. We do docket it. We do apprise you of this. You're not bound to make the payments, but we'll remind you and say, hey, Sheila, Tom, Becker, whomever we're talking to, You've got this fee coming up. Do you want me to pay it for you, or do we let the patent go abandoned? You want that rapport. You want the ability to ask an attorney or someone who, like, is a patent agent who works in this field to know, hey, here's where your patent's at. Here's what we're owed. Here's what's coming. That is a great assurance that you don't get from third parties. You especially don't get it if you try to chat BT it. Trade secrets. Now, trade secrets kind of fun. They're the James Bond of the IP world. There are two frameworks for it. For us, there's a South Carolina Trademark Secret Act. It says information included but not limited to. And notice it says these are examples, but this isn't everything. There may be other trade secrets not here. Formulas, patterns, compilations, could be a program, could be a device, a method, how you make something, a technique, again, a way to form something. Maybe you got a painting style, product, system, process, could be a design or a prototype. You may have something that can't be reverse engineered and you're going to keep it that way. It could be computer code. But here really is the quintessential essence. It has economic value, either actual or potential. Maybe you're not in business yet, but this thing's going to be the next land breaking invention in the area. It's not known, meaning, hey, we haven't done a YouTube video on it. We don't have a white paper on it. I haven't put anything in the Library of Congress about it. And you can't ascertain it just by looking at the product. If you can ascertain things, or say, you can take the product apart, figure out how it works, patent. If you cannot take it apart, you cannot reverse engineer it, I want us to really strongly consider trade secrets. I have a client, love him to death, Hard Scoop Ice Cream. And many, many moons ago, before I had so much gray hair, we had this discussion. Do we patent? Do we trade secret? We decided to go trade secret. And I'll tell y'all this, they've been my client for a long time, love them dearly. I don't know the trade secret. I have no desire to know it. I don't need to know it. I just need the client to know that they have it and to protect it. And also, there have to be reasonable efforts made to protect it. You can't just leave it in a folder that's out on the front desk that anybody can look at. You can't have the receptionist knowing about it, and the guy who cleans the closet, and the guy who installs the pipes. They can't know about it. This has got to be a secret. It has got to be limited to a certain group in the company that have need to know access, not everybody and their uncle. Now, we also have a federal Trademark Act, the Defend Trade Secrets Act, and notice it's got basically the same discussions that we talked about. Hey, what could it be? It's scientific, it's financial, it's business. But again, notice, guys, take those reasonable measures. Locked rooms, passwords on computers, limited access. If you don't do that, or if you do it in a shoddy way, and say an employee runs off and takes your trade secret with them, the secret recipe, if you've not done enough to keep it secret, a court's not going to have any mercy. They're going to be like, look, it's a trade secret. It was on you, Mr. Owner, to keep it a trade secret because it derives that value by being not known and not accessible. And so, granted, they're bad employees who do stuff and run off. They'll hack a system. Very different. You've got your footing on that one. You can say, look, I did my best to keep the secret. This guy hacked me. They used a chainsaw. They got into the wall one night. They stole the computer. Here we go. But up until those sort of extreme actions on their part, I was very reasonable. I protected that trade secret. I kept it safe. Y'all, I'm going to shut up for a second. Does anybody have a question? Awesome. Got David Ray. At some point, could you please touch on protecting IP internationally? Hypothetically, I would like to secure Japanese, European, United States, and Canadian markets with my product. Beautiful question, David Ray. You're favorite child number one. Now, this favorite child number one spot can be attained and lost quickly, so I want you other guys to jump in too. David, I love this question. So what we want to do here is to talk about what are our potential foreign rights. Oops, somebody just destroyed the question, but it's okay. I got the gist of it. So David says, hey, I want to go in some different countries. Now, granted, David's very reasonable. He's not trying to go into 20 or 30 companies. I will tell you this gets expensive. I have a pharmaceutical client down outside of Atlanta. They went into 12 countries. Y'all, it was $100,000 in filing fees. So I want us all to kind of have a cold drink of water, do like David and say, hey, I want to focus on Japan, Canada. I don't remember the others. The question's gone now. But that was a very limited number, very doable. The way that we would typically do that, David, is we will file what is called a PCT application. We'll start with a provisional. That's sort of a baby patent. It lasts for a year. During that year, you guys can go out and market. You can disclose the contents of that provisional if you wish. You're protected because that information is on file. What we're going to do, though, is looks like the chat just popped up, guys. So I'm going to move the mouse over there so for chatting. It looks like the chat is working now. It looks like David, it looks like you're now in the chat. I'll keep them both up just so we're safe. So David said, "Hey, I want to go to Japan. I'm going to go to the EU, US, and Canada. Great markets. Typically the big six to round that out are Mexico and Australia. Great first world markets, great areas to go into. Japan's very expensive. I caution you on that one. Just say, hey, make certain that going in it's going to cost more to go there. They're very isolationist. Foreign countries, you do have to fight a little harder to get a patent there. You can get them. I've done that, but be aware that hey, they do like to fight a little more with someone coming in. But the main way I would tell you to do this is first file provisional. That can be a down and dirty, but eventually it's going to have to become a patent cooperation treaty, PCT application. You then will file that at the year mark from the provisional. And you can file it at day one if everything's ready, all the nuts are tightened, this provisional application is pretty, the claims are good, and it's ready to file. But I tell most folks, file a provisional, it gives you a year. You can go out there and see how market penetration is working, how there are any R&D changes we have to make, etc. So at the end of that year, typically you're going to file that patent cooperation treaty application. You will file it with WIPO, the World Intellectual Property Organization. It's going to sit there for about 18 months. So the good thing about filing as PCT is you don't necessarily incur a ton of fees up front. It's expensive, but you pace this out. You pay some for the provisional. At the end of that year, you pay some for the PCT. At the end of 18 months, then you'll pay to nationalize. And that, David, is where you pick the countries you go into. And so I want y'all to understand that, hey, these protections are out there, but to have them, like if you're David, one thing David's not going to do is he's not going to go the disclosure route, and he probably has a product that can be reverse engineered. So he's like, hey, I want to be safe in this. I want to do it the right way. And he's already thinking of his foreign markets. So David, beautiful question. If you have any follow up on that, let me know. I've got the screens pulled up. Now, to our trade secret mistakes, not protecting them and not realizing you have it. David's got trade secrets. He's got the way that he's going to make his device. He's got vendor information he's setting up, and that's got nothing to do with how he made it, but it's going to help him market it. It's going to help him have market penetration, and you'll be able to say, hey, what have we done here? How have we done this? What do we do to protect this product? And David's already thinking along those lines, but something quintessential that he's not going to do is go disclose it because he's thinking, hey, I want a patent. So again, that's the opposite of disclosure. That's the opposite of a trade secret. Now, for our trade secrets, though, remember these are very real world things. The software that you use to make the systems go, the software you use to manage your manufacturing methods, maybe the way you've got the machines lined up in the shop makes it more efficient. You don't want to advertise that to competitors. It allows you to sell to a lower cost, maybe make things faster than they can. You don't go advertising it. Your methods for processing, guess what? Trade secret. How do you make the widgets? Well, you start off with raw materials, and the way that you convert to the widget is a trade secret. Customer lists, business plans. Now, this is something I want y'all to be very wary of in the world of AI. Right now I'm at the SBDC State Convention, so score folks, you can stone me alive if you wish. I know Mel will try, but I will tell y'all this, it is a great topic here. They're talking about cybersecurity, they're talking about AI, we're talking about it today. And one thing I want all of y'all to be aware of is that you're, as a nascent company, as a burgeoning company, as a growing company, you're going to be tempted to use these AI resources. I want you to be very careful about the ones you use. I want you to use what are called captive AIs. I don't want AIs to send information like your business plan or your customer lists out to the universe. That will happen with some AI, and you need to make very certain, are they going to use your data for training? And if they say, hey, this is going to be used for training, guys, this is not secret. A trade secret should never be put in there. I don't want a marketing plan in there. I don't want R&D data in there. I don't want business relationships in there. I don't want your pricing and your profit margins in there. Those are all trade secrets. You keep that stuff on the vest. If you're going to use an AI, you do like Milliken. Our Milliken up in Spartanburg guys, they have a captive AI. It only exists in their little universe. It doesn't go talking to anybody else. They get all the benefits of that fast thinking AI, that fast collating AI, but they do not put it out to the rest of the universe. I don't want you guys doing that either. Quick question. Who here has used Grammarly before? The program Grammarly. Cool. Two hands raised. I love it. I want you guys to go back and see which version you used, because when you use Grammarly, If it's using it for training, whatever you put into it goes out in the ether sphere. It's now somewhere else in the internet, and you're like, oh crap, how did that get out there? Oh crap, I had to check my grammar on my marketing plan. And guys, that then becomes accessible to third parties. Now, for the folks who raise your hands, thank you. I want y'all to be aware of this. And then today's a cautionary tale. It's not a horror story, but we're going to try to avoid horror stories. Now, as we keep progressing, I want you guys to ask a ton of questions. Y'all done really good, David. I love it. The folks who raised their hand, but you're not bothering me in the least. And I know I talk really fast. Now, our trade secret documentation mistakes. If you've got employees, tell them we've got trade secrets. It seems kind of axiomatic, but make them aware of it. Have them sign a policy that says, hey, I've got a secret formula and I'm going to expose you to it, and you're promising not to run off with it. You want to do that instantly. Guys, the more button just popped up. We got another in Q&A, and it's open. Y'all bear with me. Susan Medaglia. Susan, I'm going to slaughter that last name. Medaglia. I hope it's Medaglia. If it's not, apologies. I recently submitted a project on Upwork for them to research the idea that I want to design and sell. I keep feeling uneasy about this company. Do you have an opinion about working with this company? This company is named Upwork. I don't know about them per se. Susan, I'm happy for us to have a discussion offline. One thing I'll tell you guys to do is research them. Jump in there and slap in Upwork on there. Hey, is Upwork legit? Do they keep things secret? One thing you should have with them, Susan, is going to be an agreement between the two of you that's going to explain your information. If you don't have that, I would be very hesitant to use these guys. You want a situation to where you are protected. I don't want a situation to where you are worried. Bonnie Bragdon throws in, you can have Upwork contractors sign an NDA and other contracts. That is a great thing to use. It makes me a little hesitant that that is not a base one thing for them, both Bonnie and Susan. I'm with Bonnie on this one. Unless you know that these guys, Bonnie, sorry, you guys may not be seeing this. Bonnie wrote back, I would never share confidential information on Upwork. I agree with that, Susan. I want you to be protected. I don't know the inner workings of this company, but if you have to put NDAs in place, that makes my hair stand up a little bit. So I want you, Bonnie says, I've worked extensively and gotten good results. Is that with Upwork, Bonnie, or who have you worked with? I have worked extensively and gotten good results. I'm not certain the context on that one, Bonnie. Flesh it out a little bit for me, pretty please. But with you guys, any of these programs, I want y'all to look at it and make certain that you have Upwork is the platform. Okay. And so Okie dokie. And so Bonnie says she's worked with Upwork, but she does not share confidential information with it. I admire that. I think it's a smart way to do it, and that it protects you. Your relationship is with the contractor. I hear you, and that's just going to be like any other independent contractor we've got, gang. You want to make certain there's an assignment there. You want to make certain that there's non-disclosure there. You do not turn these people loose. You need to make certain that if you're using the Upwork system to communicate, that it is not keeping records of those communications. I want y'all to go into this and really kick the tires on it. And Bonnie, thank you so much for jumping in on this, because with a program that I'm not familiar with, again, I'm not going to guess, but I'm going to tell you the basic rules that work across the board. And so you use those non-disclosures. You use your ability to contract with these folks, but I really want you guys to read about the intellectual property section. I want y'all to find out, hey, if I submit something here, is it used for training purposes? Does it go somewhere else? What happens to it? Because I don't want a situation to where you guys go in blind and then all of a sudden we're like, oh fudge, I didn't realize this was going to happen. What happened here? Now, back to our trade secrets. Another way here, guys, is black box it. Keep this thing separate. If you've got a recipe and it's got multiple ingredients, have Sheila do part, have Tom do the other part, and don't let them be in the kitchen at the same time. They're very common sense ways here that we can protect trade secrets, and I want y'all to be thinking about those. I want you to understand that, hey, you're a business, and it doesn't matter if you're a single person or 100 of you, you are a business. We have to treat these trade secrets like we would any business aspect. Y'all keep going. Susan, Bonnie, I love this. David, thank y'all so far. You're not bothering me in the least, and I love the feedback we're getting. I'll stop for a second and see if anybody has another question or input. Don't see anything yet, but y'all maintain. Feel free to run with it. Now, our trade secret policy, guess what? We want to identify our trade secrets. It's the X recipe, the super secret fudge brownie recipe. Put it in there, explain what it is. Don't actually put the trade secret in there, but just have a way to describe it. You want a policy for your people, and guess what? If you're using somewhere like Upwork, you're going to want a trade secret policy with them if there's a reason to disclose it to them. If there is not, you do not disclose it to them because that kills the trade secret reasonable protections. If you've got employees to it, hey, we talked about dividing it up so that Sheila and Tom might help make the super fudge brownie secret recipe, but they don't know what the other one does, and neither knows all the ingredients. You can black box it. That's a really good way to keep things safe. Exit interviews. I realize it's hard to get somebody to sit down and explain while they're leaving. Typically, there's going to be emotions on both sides, but it never hurts to remind them, hey, guess what? You're here, and I want you to understand when you leave, my secrets stay with me. You don't take them. We've got a trade secret policy. There's things that you've been exposed to. You do not get to take those with you. Now, technological measures, guys. Here at the SBDC annual convention, we have talked about cyber all morning. And it is here, it's there, it's easy to be had, and it's easy to put in place. I don't want to hear the, ooh, I didn't know. Guess what? We just talked about it. All of our 24 attendees now know. Now, what I want y'all to do, though, is to use it. I want passwords in place. I want you to monitor your employee downloads. If somebody is downloading the super secret fudge brownie recipe and should not, I want you to be warned about that. I want them to say, hey, we've got Kevin over in accounting and wanting to know the super secret fudge recipe. What the devil? Kevin, you don't need to know that. You're an accountant, man. You push books. You do not touch the fudge. So I want y'all to set these protections in place to protect you. Now, here's the thing that's usually confused in documents, and we're going to cover that right now to make certain everybody's kosher. We do have a new question. I'm going to pop right down here. Lisa Bundridge, you may have said this, but what about getting a signed NDA? Does that protect my patent? If so, do you have one you can share with us? Sure thing. What I can do is I will send David a copy of a NDA that I use. It's kind of a short one. It's a down and dirty that will get the job done. David, remind me to send you a copy, guys. I'm in a hotel room right now, or I just sent it on. But David, remind me to send that to you. I'll be happy to disseminate it. But Lisa, I did say that, and I do want you to use one, because what I don't want to have happen here is a situation to where we're disclosing secrets to folks and we're not doing it in a protected way. We're just shouting to the planet. That's not what we're taking away from today. What we're taking away from today is we whisper when we talk about trade secrets, and we only whisper in certain places to certain people. Now, back to this confusion. A lot of people will confuse a trade secret with confidential info. I see it in documents all the time, and I don't want you to get fooled by it. I have been, but I don't know who accurate or outdated it is. No worries, Lisa. We'll get you one. I mean, hey, at least you've made an attempt at it, my dear, and that counts, because at least you can go to the judge and be like, hey, this might not have been a state-of-the-art NDA, but by gosh, I tried to have them do it and use it. So don't be freaked out just because it wasn't printed off an attorney's printer an hour ago. I read through that, Lisa. You're good. She corrected the wording in it. It's just like me typing, my dear. We'll get there eventually, but I do understand what you were saying. What I want y'all to understand, though, is in these documents, if you have a section about confidential secret information, I want there to be a cutout for my trade secrets, because your trade secrets last forever, gang. And you look at Coke. You know what? The Coke trademark is going, or trade secret is going to last a really long time, because they do really, really good at protecting it. Reasonable steps. Only 2 people in the company have access to it. They've got some beautiful limitations in. But another thing they do? Their contracts will put in there, hey, if we're talking about confidential info, that doesn't include a trade secret. And hey, if I'm talking about a trade secret, nothing in here puts a time limit on it. It is protected as long as we keep it a secret. That's the way I want you guys to do this. I was working on a document the other day, sent to me by a client, had a confidential information section, and it mentioned trademarks specifically, trade secrets specifically, but did not exclude them from the coverage of the confidential info. You want them kept a secret. You want it to be known that they're going to exist infinitely as long as they are still a trade secret. So be careful with your documents, guys. And ChatGPT does not get this distinguishing factor. You'll tell it, hey, I want a trade secret confidentiality agreement. It'll spit something out. We'll talk in a little bit about how that's a very bad recipe anyway. But I want y'all to understand it is not an attorney. It is an educated hunting program that puts words together for you, draws pictures for you, provides answers. further documentation considerations for our new hires. Make them aware you're going to be experiencing a trade secret. You're going to introduce confidential info. Firewall information. Do not allow somebody in accounting to get the super secret fudge brownie recipe. We don't want to do that. Guess what? Make certain that your new hires, you've got the ability to restrict them. If they're going to leave, guess what? You can't compete with in this industry in these areas for this amount of time. It's got to be reasonable. You can't say, hey, planet Earth forever, but you can definitely say, hey, a few counties around Greenville for 2 years. So there are definite things that you want. You can't do this in all jurisdictions. South Carolina is very employer favorable. You don't get those protections in other places. So again, problem with ChatGPT is ChatGPT just pulls language down. It does not sit there and think, oh, wait, are they using this in South Carolina? Oh, wait, are they using this in New York? You got to be very careful about that, guys. New question. Tanya Ferguson. I have a client that is developing a new product. They're leaning towards not getting it patented and making a public announcement type thing. So they're going the disclosure route, they think. This product has potential to be a disruptor in the targeted market, meaning, hey, they haven't done this before. Tanya's client's sitting there kind of splitting the atom. Reverse engineering is a definite possibility. There are trade secrets involved, but I'm thinking we should look into patenting before we provide samples to possible customers. What are your thoughts? Tanya, first of all, I think you asked brilliant questions, and I think you're taking really good care of this client. Y'all, that's beautiful. Y'all should screenshot this because, Tanya, that's exactly what we don't want to do. If we've got a disruptive technology, we don't want to be, what is the old saying? Penny wise and dollar foolish. We want to be to the extent of, hey, guess what? We have a potential disrupting product. And Tanya, think about what we talked about. There are different versions of patents. We may be able to protect the look of it. We may be able to protect how it works because there's utility patents and design patents. I have patents, clients all the time will come in, we'll do a patentability search and be like, hey, we can't get a utility on this, but it's got a novel look to it. Get a design patent. And you'd be like, why would I do that? Well, they're pretty cheap. They're about the price of a trademark, and they issue a lot quicker than a utility, and they last 14 years, and you don't have to pay a maintenance fee. But nobody can look like your device. That's a very cool thing. But Tanya, I'm with you. If this can be reverse engineered, we need to do a Caesar thumb up or thumb down on patentability because once it's sold, y'all, that's a disclosure. We covered that back in earlier slides. I can get everybody here a little motion sick. We'll go back a couple, but that is absolutely a disclosure for a patent is selling it, putting it out there to those third parties. We do not want to do that until we have had a sit down discussion of here's what happens if we do this. Here are the rights we lose. Because, we talked about David going to these foreign countries. If they sell this critter, then you've got a year from that sale to file in the U.S. But Japan, Europe, Canada, all gone, all lost, cannot be recouped, gone forever. So Tanya, I agree with you. We need to be really, really careful with this client. We need to educate them, and they can make the full decision to be like, hey, I'm just going for first on shelf. I don't care. But that decision needs to be made in the knowledge of, hey, you've got a disruptor, man. You could be a cutting edge device. It may be something that others want. But if you do first on shelf, guys, you don't have protections. You're out there in the Wild West hoping that one of the big boys doesn't look at your disruptive product and decide, look what I'm going to do with all my resources. New question. Lisa Wilson. I'm starting an online magazine for women. Should I trademark my logo and copyright my exclusive content? Lisa, beautiful question. Yes to both. Your copyrights will arise once that magazine is done. But if you have the penultimate issue, you've got the issue, and you're like, man, this solves every problem a woman's going to have from age 35 to 60, we would want to register that copyright. And the reason I say not to do it for everything is you're going to have a lot of issues. And I can teach you how to file your own copyrights. I do that for what I call my artist clients. Someone publishing a magazine is definitely an artist. Trademarking your logo, absolutely, because once you're out there, once you're in this niche, you don't want somebody touching your stuff, guys. That's a big thing about IP is it prevents folks from touching your stuff. And what I want y'all to understand is it could be through a patent, it could be through a trade secret, it could be through a copyright, it can be through a trademark. But Lisa, those are awesome questions. Happy to help you do that. We will want to do a clearance search on the marks. That's something we'll actually do in the next score session is I'll show you guys. We'll come up with a mark and we'll do a little exploratory search and say, hey, here's what you go here. Melissa Weaver, should you trademark your slogan? Melissa, if it's going to be tied to you for a while and it helps you bring in customers, absolutely. You've heard of that just loving it from that little, there's a McDonald's literally out my window. Absolutely trademark your slogans. If it's something you're going to stick with, like just do it. And if it's going to be the brand brand that sticks with your company, there you go. Absolutely look at trademarking. Now, I'm not saying trademark everything, I'm not saying copyright everything, but the ones that are bang for your buck, the ones that help identify you to consumers, absolutely protect them. Again, trademark is just like a design patent. They're on the very low end of the pricing spectrum, but the protections they provide to you are incredible. Still a little trivia question, guys. Now, all of you have to participate. I know we've got 24, we've got 26 folks. We've grown. So, all 26 folks, I want y'all to type in really quick, what is the world's oldest trademark? What is the world's oldest trademark? I'll give you a couple hints. It's not the Bible. That's always guessed. It's almost guessed number one religiously, no pun. But what is the world's oldest trademark? It is not the Bible. Okie dokie, starting to get some guesses here. Let me go down to our questions. Susan has come up and said General Mills. Nope, good guess. Very old, but not quite Susan. All right, got some more coming in here. Coca-Cola recipe. Laura, I like how you're thinking. Oh, Melissa Weaver, my dear. She says it's Pilsner beer. Oh, Melissa. Further hint, it is absolutely a consumable food product, very similar to what Melissa's talking to us about. It is the world's oldest trademark. All right, got some new ones coming in. Ford, Susan, great question. They're very old, but they are a baby compared to this mark. This mark is nearly 650 years old. So now everybody's going to stop me like the U.S. is only like 250, do some rough math. So it's not a U.S. brand. It is a foreign brand. It is nearly 650 years old, and it is a very similar product to Melissa's Pilsner beers, or beets. I'm sorry. Maybe it meant beer, but I translated it as beet, and it says beet. Um, any other guesses, gang? And I love y'all playing the game with me. I think it makes our conversation so much easier. Bass Pale Ale's red triangle logo. Look at Lisa Bundridge coming from the top rope. I love that, Lisa. I will go ahead and spill the beans. It is Stella Artois beer. They have found burnings on old casks of beer using the Stella Artois trademark. Can you imagine being the person in charge of a 650-year-old trademark? The stress levels you have must be like Godzilla level stuff. But y'all understand that. And this is back to the question of, do I protect my logo? Do I protect my slogans? You absolutely do, because you've got the potential for them to outlive you and your grandkids and your great grandkids when your business takes off. Stella Artois beer, guys, you can go to Publix, buy it this afternoon. It is everywhere, and it is the world's oldest trademark. Now, keep going on. What are our benefits of having these trade secrets? Because remember, trademark's a critter, trade secret, very different critter. So what I want us to understand is our trade secrets can last indefinitely. You know, that Stella Artois trademark, got to be kept in force, got to pay the fees. You missed that, that's trouble. You're fired instantly. Maybe they fire your whole family. But trade secrets are easy to maintain. You keep them a secret. You use reasonable security. They're cheap. You don't have to pay for it. And you should want to keep this a secret. And guess what? Your aura of mystique. I don't know if any of y'all are television junkies, but I love the old Bush's baked bean commercials. And Alvin, I see your question. I will get right there to it. But what we're talking about is Bush's baked beans and trade secrets for a second. If y'all remember the commercial, you had two guys or one guy in a chair, and you had this old hound dog in there. And the hound dog was like, "Hey man, you come to me and I'll tell you the secret." There was no secret. It was beans and it was sugar and it was cooked. But you know what? They used that mystique to capture 80% of the freaking bean market. Chances are all of you had Bush's baked beans at some point in your life. All right, back to Alvin Zellers. Alvin says, I want to start a deer hunting formula and wonder how to get it started. I have a secret and would like to get it patented. Okay, so Alvin, here's what we're talking about, my son. We do not want to patent secrets. A patent and a trade secret are exact opposites, matter and antimatter. What you want to do is to be able to say, hey, folks, Bush's baked beans. I'm Alvin Zellers. This here's my deer formula. I will bring in a white tail that has 16 points, a bad attitude, and he's going to dress out at about $1.80. And so that's what you want, Alvin. What we do not want to do is to explain the secret sauce. You, Alvin, or Coca-Cola? You don't see them putting that recipe on the back of it. They'll tell you there's carbohydrates and all this stuff in it. But what you're going to do, Alvin, is you are my trade secret man. You are my chef. You are my chemist. The reason I say that and the reason the Coke has been so great over the years at keeping their secret a secret is that chemicals are very hard to reverse engineer. You've all walked down the aisles of Kroger or Publix or Pig, wherever you shop, and we've all had at some point the bad choices in life to pick up one of those off-brand Cokes and you drink it. And the human taste buds are entirely a beautiful system, but they're also very precise. And you can taste the difference. You're like, nope, I bought Rock Gut Coke on me. I knew it. I was trying to be cheap. I got bad Coke. Alvin, that's the way I want you to go with this deer hunting formula. We're going to keep that a trade secret. It's going to be very easy for you to do because they're cheap and you're going to keep it a secret. But what I want you to do is we're going to brand this bad boy. We are going to get a trademark so that you can go out there with your Bush's baked beans and say, hey, Alvin Zellers, here's my secret deer formula. Can't have it, but it'll bring you a great big deer, 16 points, dress out of the $1.80. Thing will basically walk up to you. That's what you want to do, Alvin. That's what you want to be in this situation. Beautiful questions. I love this. I love the fact you're all coming out like this. This is awesome. Keep going. We've got about another 15 minutes. Getting ready to hit the AI section. I want y'all to understand this, though. I want those non-disclosures in place. We've talked about that. Even with a prospective buyer of your company, if it's grandma coming in with a sack of gold, I still want an NDA in place. I want you to be able to show a buyer, hey, here's all protective stuff. Here are my passwords. Here's my security. Here's my locked rooms. Here's my documentation. I tell my employees we've got trade secrets. I tell everybody, hey, you're signing the trade secret policy. We have exit interviews to remind them, hey, doofball, you touched the super secret fudge recipe. You can't tell that to anybody. Now, to patent or to trade secret, Alvin, that was beautiful, my friend. You keyed us up for this so well. You know, there's disadvantages to filing a patent. You've got to tell everybody about it. And like we were talking earlier on about Tanya's client, if they can reverse engineer your product, and if it's going to be a disruptor in the market, they're gonna take that thing apart like a toddler with a Tonka truck, and they're going to figure it out. You need to have protections in place so they can reverse engineer it. Alvin, my friend, you're lucky because you, my sir, are a chemist. Very hard to reverse engineer formulas like that, especially ones aimed at like hormonal based, maybe chemical based that you'll be using for deer attracting. But once those secrets are made secret, guys, there is no genie. You can't put it back in the bottle. You are done. It must stay a secret. Trademarks are more difficult to enforce than a patent. Patent's patent. You see it. Here's the claims. Trade secret, there's going to be a lot of questions of, was it protected? Did you use reasonable protections? Did you do what you should have done as the owner? So I want you to understand too, human beings have a tendency to think alike. You know, Alvin, guess what? Even though we're not going to patent this thing, there is a danger that there could be an Alvin in North Dakota coming up with something very similar, maybe even identical. And so that is always a danger, but it is a much less of a danger than filing a patent application with your trade secret in it. You know, it's always in the realm of possibility somebody comes out with something similar and they may try to put a patent on it. They shouldn't if they want to keep it a trade secret, but maybe they're not as smart as we are and they go ahead and do that. But I want y'all to understand there are dangers to both types. If it's a patent, you're telling it to everybody. After the patent expires, everybody in the uncle gets to make it or use it. That's the change off for the monopoly. Again, here's a little chart on this. And y'all, if anybody wants a copy of this, David has a copy of it. Here, Bina will be happy to send it to you. You're happy to have it. I want y'all to feel free to look at it. Something just popped up in the questions. All right, got a new one. Anjanita Yates Johnson. I'm making a natural lotion product that I would like to trade secret. As a topical product, ingredients have to be listed because of allergies. Is there a risk of someone reverse engineering, or is it better to TM and be known as a name brand with a slogan? Anjanita, I love that question. Now remember, look at the back of a Coke bottle. They got to tell you what's in it. They don't tell you how they make it. And that's the important thing too, is you, Anthony, you and Alvin are my chemists, my dear. You are going to be making a lotion product. You're going to be putting ingredients through a process to get there. You don't put that on the ingredients. You just have to say, hey, there's some cocoa butter, there's some shea oil, whatever it is you've got in there. And you'll notice, look at the back of a Coke bottle. Everybody go to QT this afternoon, or Spinks, whoever your poison is, turn that bottle around and you're not going to see the trade secret. You may see the ingredients, but you will not see the trade secret. And Shanita, that's what we want to do. You still will want a trademark because you will use the trademark to be your public face of the trade secret. Like Coca-Cola, we all recognize that swirl, the red and white symbols. We get it. We see that, boom, you know it's Coke. And so that's what you want to do, Anjanita. That's what you want to do, Alvin, is let the trademark act as the public face for the trade secret. Because with you guys being chemically based, it's really hard to reverse engineer it. And notice, All you got to do is show them the back of the label. If you're Alvin, you're going to be saying, hey, there's some putnam in here, some sorghum or whatever it might be. It might be some hormone 22. But you're not going to say, hey, here's how I prepare this. Here's how I bottle it. And oh, be wary if you cook it for more than 10 seconds. This temperature, boom, hormones gone. Deer hates you. Deer attacks you. Deer is not friendly anymore. So I want y'all to understand that just because we have to show the ingredients doesn't mean we share the trade secret. And I don't want that anywhere, guys. And Janita, Alvin, if y'all set up YouTube channels, I do not want there to be a trade secret discussion on the channels ever. If any of you guys are TikTokers, I do not want a TikTok trade secret discussion for anybody here. What I want is to do something like they used to do for the Neelys on the Food Network. And a young fat kid got a pot gut, love to eat. And so I used to watch the Food Network religiously, and the Neelys had this awesome rub that I've tried to replicate, but they were brilliant. And they hit it within paprika. And y'all know paprika, and on my screen, Alvin's symbol comes up as almost the exact color of paprika, that real deep red. And you can hide salt in there, and pepper in there, and garlic pepper, and onion powder, anything. And they would use what they call the Neely's rub, and they never told you how to make it. And Janita, they were on television all the time, and they never told you how to make it. And that's what I want from you guys. If you go trade secret, Alvin or Janita or anybody else, you never tell them how to make it. That's an in-house secret. We're going to black box it. There's only going to be a couple people knowing what to do. Now, y'all, let's jump over to AI real quick, and y'all keep asking questions. I love these. As you've noticed, I was telling David earlier on, y'all's questions invariably take us deeper into the presentation. Now, we're switching gears for a little bit. We're going AI. We've talked about this a little bit. We talked about Upwork. We talked about Grammarly. This was me clowning around on the computer making this presentation earlier in the week. I said, hey, I want a picture of Mona Lisa riding a bucking bronco. I don't know what I got, but I'm not certain that that is the Mona Lisa riding a bronking bucko. I definitely did not tell it I want psychedelic cactus land. I did not also tell it that I want some sort of pigeoned hawk up here that might even be a grouse flying above her. I definitely didn't say that I want the horse to be tattooed from the neck down. But the AI was kind enough to explain its reasoning to me. And it said, hey, and this literally is just a screenshot of what it explained to me. It's a surreal and imaginative artwork of the Mona Lisa riding a bucking bronco in the Wild West. She's wearing a Renaissance style dress and a cowboy hat. She's holding the reins in one hand and waving them in the other. The bronco's in mid-buck, kicking up dust in a desert landscape with cacti and mountains in the background. The scene's dynamic and full of motion, blending classical art and Western cowboy themes. I kind of view it as an acid trip. That doesn't look like the Mona Lisa. It freaking looks like the anonymous mask. And I want you guys to understand this isn't just me typing this to an M365 Copilot. Draw a picture of the Mona Lisa riding a bucking bronco. This is what I got. Guys, this is why we're talking about AI. I gave it what I thought was a very straightforward instruction. I get an art explanation of why I got a psychedelic pony. And I need y'all to understand this thing's going to generate psychedelic ponies. It's going to put the anonymous mask on the Mona Lisa. It's going to give her a freaking riding crop that's like way too long. And yeah, a lot of subtlety there. But what I want us to understand here, guys, is that these AI are a toddler on chocolate. They're very energetic and they are very eager to please. But a toddler on chocolate does not make the best decisions. I know. I've got a little niece named Elise. We call her Cheesy. She loves cheese. So instead of chocolate, I can give her sweetened cheese. And I can trigger toddler syndrome on that. My sister hates it. But I love it because she's like a little dynamo. And you send her forth into the universe to do creative things, just like these AI. Now, there's some things they won't do. Plagiarizing Meatloaf here a little bit. Nobody scream at me. But I said, hey, show me President Trump wrestling Elon Musk. And notice I didn't say anything bad. I didn't say mud wrestling. I didn't say in a bikini. I said, I want to see President Trump wrestling Elon Musk. Copilot says, can't do that, brother. So these are real public figures. Can't put them in these situations. Could be controversial. I can help you do something fictional. Now, that's what I want y'all to understand, is this seems to be a very reasonable response. It would almost trick you into thinking this thing thought about it. It didn't. There's just a list of subjects it can't do anything with. President Trump, Elon Musk being in those situations. I'm certain most of Hollywood's in there. Most of the political figures are in there. None of us are in there. I could ask you to see Doug Lineberry doing that. You would not want to see me in a wrestling leotard, so I'm just warning you early on. But it may do it. So be very careful, guys, because it may seem like they're governing rules here, but which governing rules said, hey, I want a psychedelic pony? Which governing rules said, hey, put the anonymous mask on the Mona Lisa? Got to be really careful what we ask for, kids, because these AI are a toddler on chocolate. Now, I also said one thing earlier, too. Do not use the AI to generate a patent application. I did that very thing. I asked the same AI, create a draft patent for me. And I didn't put the whole thing in here. I'm not going to bore you. But damned if it didn't just start spitting it out. Here's your abstract. Here's your background. I just said, hey, create a patent about a wooden toy. And trust me, guys, you can feed these a lot of information and they will feed stuff back. But here's what I want us to be worried about. Guess what? That training AI, it's the devil. I don't want y'all falling for that. I do not want you using AI that says, hey, whatever you input is going to be used for training. I want you guys to be, I think it was Susan who said, don't ever give them anything serious. It was Bonnie. Bonnie was like, do not ever give them anything confidential. I don't want that done by any of y'all. I want all of y'all to be like, hey, I want us to be protected. I don't want to do something silly. I definitely don't want anything that can do that hurt y'all. Text and data mining, guys. Guess what? When you're using these companies, they're taking your info and they're not just doing that. You may be giving them access to your other systems. So you have to be very careful. Somebody read today at the event I was at, somebody had read the terms and conditions for PayPal and decided to stop using it for their company because guess what? It said, do you do one on sister? Oh, yeah, absolutely, Alvin. I do that. I'll slap in let's see if I can get my direct dial on here. Y'all can call me at any point you wish. I love score. Just tell me you were here today. That is my direct line. Hope that popped up. Trying to see if it came in. I'm also going to type in my email. You can get all this from David too, but I'll put it in here so y'all can see it. Hopefully it's populating. I can't see on my end that it is, but that doesn't mean that it's not. But y'all, I do this. I love small businesses. You guys are the bread and butter of my practice. I love the fact that y'all are out here with this energy. That's why I do this, gang, is to let y'all know, hey, we're all out here and we're in this together. Here's my email. As I click it for the right time. Awesome. Thank you, David, for letting me know. But y'all feel free to reach out to me. Say, hey, I'm one of David Ash's kids. I was there on this presentation. I'll remember. We'll take care of you. But I do consultations, guys. This is how I pay my rent. It's how I'm putting my kids through college here in 2 years. I'm an IP attorney. I do patents. I do trademarks. I do trade secrets. I do copyrights. I do the docs involved. The good thing is this is all federal, so it doesn't matter that I'm in South Khaki. If you guys happen to be in North Carolina or Georgia or Puerto Rico or wherever you're at, I can help you. I've got clients in all those places I just named. Happy to help all of y'all. One thing I want us to do, though, is to understand with this AI stuff, guys, it's kind of like a toy. It's very attractive. It's very gleamy. It's very bright and shiny. It can also be very dangerous. Rattlesnakes are pretty from a certain angle. I don't want y'all being bitten by a rattlesnake. You're most welcome, Alvin. And I love the fact that y'all are asking these questions. What we're about today is this communication. And when y'all communicate, and especially with these AI, I want y'all to understand there's certain things you can't tell people. There's certain things that have to remain close to the vest. Your unintended infringement, guys. Like when I asked this thing about the Bronco, the Mona Lisa's been out there. There's no copyright on that. It was Da Vinci or whomever painted that. This Bronco, I don't know where it got it, guys. This picture could have been taken from a brand new Western catalog for boots. Like I'm a big boot wearer. I love to go. Love all Los Altos, love corral boots, awesome boots. This might have come off one of their pages and I don't know it. So I need to be very careful what I ask AI to do for me. And also, we need to be very careful about ownership because, if you use AI to create stuff, I've listened to horror podcasts consistently and fervently. I'm driving back to Greenville here in a little bit and I'll put on horror podcast. But when I do that, one thing they tell you about the submissions is they don't take AI works because you don't know who owned them. And so that automatically knocks out an entire genre of folks who are like, well, I used AI to create a horror story and it's great. Nobody wants it because you don't know who owns it. And guess what? How much human involvement was there? Did you actually send in an outline? Did you just say, hey, generate a horror story? And here it came. You got to be careful. When you said generate a horror story, did it go and steal something from Stephen King that was just published? It's got an existing copyright and a massive legal team behind it. I want you guys to be very careful. Laura Colson, she says, if I use AI to generate a LinkedIn article about passage of a House resolution bill, do I risk any copyright infringement? I'm extremely ignorant. You are not ignorant, Laura. What you're doing is being inquisitive and you're asking good questions. We're all ignorant, my dear, because here's the trick. You don't know where that AI gets it from. And if you are saying, hey, generate something for me, when I said generate the Bronco, I have no idea where it came from. So you do need to be very careful with that, Laura. If the AI generates something, and this is for anything, I want you guys to read thoroughly. And if you're going to publish it on LinkedIn, I want you to make it your own. I want you to take and be like, hey, I did this. Wouldn't kill you to say, hey, this was made with the assistance of AI. Because what I don't want to have happen is you take this thing from AI and you don't kind of look behind it. Because if it starts throwing in illustrations or sound files or something, guys, we don't know where that came from. And so, Laura, there is a very real danger of it. What I would tell you to do is to say, hey, Give me an outline of this, and then you make an original product from that outline. That makes me feel better. I've got clients that will send me chat GPT docs, and sometimes they're the most bare bone things you've ever seen. And so that can be fleshed out. And if it sends you something very complex and very detailed, where did it get that info? That is a question that y'all need to ask. If you don't know the answer to that, we've got issues. Further negative impacts, just like Laura said, hey, I could get in trouble for plagiarism or copyright infringement. Guess what? This may make humans fatter and lazier than we already are. Like, yeah, the computer will do it. I don't think anymore. You guys have all seen Wall-E, where he's abandoned on Earth and he finds humanity, and they're all obese, overweight people sitting in chairs, and they don't think anymore. The computers do it all for us. That is a potential. Erodes our human creativity, erodes the human spirit. Output issues. Guess what? Toddler on chocolate, gang. I've got some other presentations to where, and y'all, that is my 1 o'clock mark. I am going to shut up. I'll mention briefly to finish this thought, our ethical concerns are out there. Copyright infringement. Who created this? Who owns it? Guys, I'm on hush. I am willing to stay on, but I want y'all to ask any questions you may have. Still looking here. Y'all let us know if you've got anything else. David and I can definitely hang for a little bit.
Yep, I'm glad to. Doug, thanks once again for a great presentation, very helpful. One piece that I will highlight is that idea of putting together your document, whether it be a marketing plan, a business plan, or any other document, and just leave a section where you would use that IP information, and don't put it in as long as you're working on that in a public space kind of thing, and keep that for private and submitting it to your financial institution or your funding source that you want to submit a document to for whatever reason. Just make the space and put it in only for them, kind of thing. So thank you very much. Thank you all for being here. Once again, score.org, and I will be sending out the slides shortly, and either this afternoon or tomorrow morning, so that you all can have the slides. The video copy of this will be available on our YouTube page, Piedmont Score on YouTube, within about a week. They come up. And so several others that Doug has done in the past are available online and for you to consult if you'd like to.
And y'all, we've got some questions floating in, not to talk over David, but I'm trying to address them to everybody and post the answers for it. But y'all, look, use the David Ashes of the world, y'all. They're awesome. You are lucky to have David. You're lucky to have that field experience. I mean, the man's well-traveled. He's well-heeled. He's here to help. And he's here to make certain, like, Tanya's telling us about her client with potential trade secrets, everything else. I want y'all to know we appreciate y'all being here today. We appreciate you asking these questions. But you guys feel free to reach out to me or David with any and all questions. My contact info is posted, obviously. If you want a copy of this, let me know. David, ping me to send you that NDA, and I'll give that to you tomorrow when I'm back in the office.
Sounds good.
Everybody, thank you for your time. You were awesome. I hope you enjoyed this. And again, use SCORE, use David. You're not going to do any better. See everybody and have a great weekend.